Welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries. My name's Tony Carbone, personal injury lawyer, 30 years experience. With me tonight I've got John Karantzis, accredited law specialist in workers' comp in a major law firm. Good evening, John.
Hi, Tony. Hi, Viv. Hi, viewers.
And Vivian Ryan, the lawyer come marketing guru in a major marketing company. Good evening, Viv.
Hi, Tony. Hi, John. Good evening,
Now,
viewers.
Tonight, viewers, you've got to stay tuned. We're going to be talking about the rights and plight of sports people, and we've got Brendan Schwab on board.
However, before we get to that, Tony, what's in the news?
Well, there's been a lot in the news lately, but the one that's really interesting is this claim by Carl Williams' ex-wife, Vivian. What's your take on all of this?
Well, look, this is really interesting because Roberta Williams and her daughter have now been entitled to compensation as a consequence of the death of Carl Williams. Look, it's a victims of crime discussion point.
No, it's not victims of crime, Viv. John, this is a wrongs act because...
Why is it different to the victims of crime?
Because the victims of crime legislation doesn't give you a lot, Viv.
Okay.
And under the wrongs act, if you can prove that you've suffered a psychiatric/psychological injury as a result of someone close to you being killed, which has happened in this case, then you're entitled to sue if you meet the threshold of more than 10% psychiatric impairment, John.
So, Tony, in this case, Roberta Williams is claiming that as a result of the negligence of the state government and the prison facility, her husband was killed, and as a result of that, she suffered psychiatric shock.
Yes, a nervous shock.
Exactly.
And so she's got a properly diagnosed psychiatric injury, Viv.
So arguably now she's entitled to a payout of up to $742,000.
No, she'll never get that. Her claim primarily is for pain and suffering, loss of enjoyment of life.
Yes.
Medical and associated treatment, and she's never going to get the penancy because he was locked up for minimum 25 years. So how can you claim dependency when the person that you're saying you're dependent on was never going to be earning an income?
So let me ask you this question. Recently, Carl Williams' daughter has been in the news with alleged claims of which have been involved in some criminal activity.
Yes.
Would this lead itself to weigh in on whether or not this would help her claim in this arena as a consequence of those actions?
Probably irrelevant, isn't it?
I don't think it's relevant to the Wrongs Act claim. If it was actually a crimes compensation claim, your own personal conduct and demeanour could impact on what you get.
Exactly.
Yeah. But I guess if it went before a jury and they took a disliking to her, John,
everything gets
instead of awarding her, say, 200, they might drop it back to 100.
Now, obviously, these guys are famous in their own right. Or
infamous.
Yes. Notorious. Now, what does that then mean to other people, other lay people who aren't necessarily in the media? Do they have an opportunity to claim compensation similarly if they've been in similar circumstances?
Yeah, if one of their loved ones has been maimed or killed in circumstances where the Wrongs Act applies and you're satisfied of thresholds, the answer is yes, Viv.
And is the Wrongs Act, is that a national legislation?
No, it's a Victorian piece of legislation which is sort of the rest of the country's got similar type of
replicated in different areas, exactly.
But with subtle variations. Yeah. Let's get on to this one. Viv, you should be able to give me a lead on this. Mums lead Fair Work complaints. Unfair choices for pregnant women. What's this all about?
Well, this is the age-old adage of work versus becoming a mum. Seemingly 50% of all claims in the anti-discrimination arena come from mothers who have been in some way, shape or form discriminated against once they've become pregnant and once they become mothers. It's really difficult. It's a difficult one. I mean, obviously I'm a mother of two, and so I'm very much involved in social circles where we are, encountering lots of working mothers. Recently, a girlfriend of mine who just announced she was pregnant to her employer is already being given different roles within her work environment because of the fact that part of her role is to actually taste food, and being pregnant you can't taste a lot of food.
Okay.
Part of her role as well is to travel quite extensively, and when you sort of get on into your, I think after 32 weeks you can't actually travel. So, you know, there's arguments for and against. So from an employer's perspective, is that then discriminatory because it's a part of her role?
I would have thought that, John, if she can't really taste the food because of her pregnancy, I think it would have been fair. She sits down with the employer and says, look, I'm not going to really be able to comment about this.
That's a fundamental part of her role, but does that give rise to a claim in discrimination?
Oh, I don't think so, do you, John?
It's difficult, Tony, isn't it?
I mean, that's an interesting circumstance. Equally, the other thing is returning to work. So mothers are only entitled to their role back, and a lot of mothers actually only want to go back part-time. So, you know, it's a really difficult one.
Yeah.
At the same time, I think there is a real onus on the employers to ensure that they do maintain a certain standard for working mothers and pregnant mothers or pregnant women. Because, you know, they're contributing to society.
Exactly.
Viv, what I've found in recent times, employers are becoming a lot more savvy in terms of how they deal with ladies that go off and have children and come back, because they find that even if they're working reduced hours, and in our situation, right, we've got a couple of very experienced female lawyers who are working probably 50% of their hours, and they're probably some of the most productive
They are the
people
most
in the
efficient.
law firm, aren't they?
I have to say,
Yeah.
I truly believe that most working mums are the most efficient. You want to give something you want something done, you give it to a very busy person, and mums
Exactly.
know how to
I agree
organise
with that.
themselves. So, yeah, look, it's a constant problem.
It depends on the employer. There's other employers that won't give working mums a go, especially if they're inexperienced employees, and you know, that's a shame.
It could impact on their promotional prospects, because the employer sadly takes the view, we're wasting our resources by spending money on someone that's not going to be around.
Correct.
Do you know what I mean?
Yeah.
Anyway,
And a lot of people don't even...
It's a very delicate subject.
Yeah, and a lot of women don't even actually make, you know, any sort of noise about it till you just sort of get on with things, which I think is a problem. But anyway...
We could do a whole episode on this.
We certainly could.
All right. Drug patients are causing absolute havoc, wreaking havoc in hospitals, John. Doctors and nurses are getting assaulted, and it's causing all sorts of problems. What should happen?
Not only alcohol, but ice. It's all these drugs, Tony.
Ice is a massive problem.
It's an endemic. But in the end, the hospital, the facility needs to provide a safe workplace. Security. There has to be security guards. There has to be appropriate doors. There have to be separate entrances.
Yep.
Michael Wong, the neurosurgeon that got stabbed and he's lucky to survive, he called himself for separate entrances to the hospital to be you know fixed. Otherwise, this will occur again.
Well,
Viv, I think having security is probably the most important step.
I agree, but I think the governments need to get involved now. I really think they need to step in. They need to set some examples, set some boundaries. There are people who are waiting waiting to be cared for, and waiting longer than necessary because, you know, the medical staff are being exposed to assault whilst they're waiting for care. You know, this is becoming an epidemic.
Well, the real problem too, isn't it, that if the doctors and nurses are worried about their safety, maybe someone that is deserving won't get the appropriate medical attention.
Exactly.
Is that a problem?
That's exactly what's happening.
Anyway, this is something that we'll probably need a whole episode again. What about the workers' compensation system in South Australia changing, John?
Look, Tony, there's good signs there. As we know, previously there was no common law entitlements for workers injured there. You couldn't get a lump sum payout, Tony. But now the new government is passing legislation whereby they could access this, but on a very limited basis, and we want to make sure that it's not as limited as what they.
It's a very onerous sort of scheme, isn't it?
Exactly.
It's very hard to achieve the thresholds to be able to sue.
Exactly.
Unless you're suing a third party.
Yeah.
So is the intention of the legislation to get people back to work faster, or?
That's the intention of all workers' compensation regimes, Viv. But the point John's trying to make is, if you've sustained nasty injuries, can you then claim a lump sum? And John's saying it's going to be very hard.
It's still difficult
with the amendments that they've passed.
And the system, as it is in Adelaide, in South Australia at the moment, is You're locked on weekly payments. You're on the system for years.
Yeah.
You don't want that. You want to be able to access a lump sum payout and then move on with your
become
life.
productive again.
So essentially, people really need to contact a lawyer in South Australia to see whether or not this legislation is going. It's actually effective from July next year, isn't it?
Exactly.
Yes. Guys, before we go to a break, believe it or not, footy tops the injury list for the most people going to hospital job.
I'm not surprised.
It's just bizarre, isn't it?
Yeah.
The AFL code. So we need to talk about whether or not they have a right to compensation.
Well, Brendan Swab's coming in after the break, so viewers stay tuned and we'll see what Brendan Swab's take is on all of this. Viewers, welcome back to the show. As I said before, we're very fortunate to have Brendan Swab tonight. Brendan is the General Secretary of Australian Athletes Alliance. He's been a number of things. He's been on the Richmond Committee. He's a lawyer. He's been involved in so many things. And on that note, Brendan Swab, good evening. How are you?
Yeah, I'm good, thanks, Tony.
Now, Brendan, tonight we're here to talk about workers' compensation for players and other sports law issues. In your role, what essentially do you do? What's your primary function?
Well, our primary function is the advancement of the collective interest of the players, of course, and that involves any number of issues. But I think as we sit in 2014, the most important issues would be a fair share of the wealth of the game, protecting players in the event of injury, the growing concerns over health and safety we've seen in all of the sports, for example, concussions, and increasingly getting that balance right between the integrity and the best interests of sport and the rights and well-being of the athletes.
Just on that point, assuming one of the footballers playing for one of the bigger clubs was injured and the injury finished their career, how would they be covered?
Well, it depends what sport you're talking about.
Let's say it's AFL.
Well, for all of the athletes in Australia at the moment, there's no statutory protection in the event of injury because athletes are excluded from workers' compensation. The problem that means is whenever we sit down to negotiate a collective bargaining agreement, the sports are at liberty to say, well, we're not going to insure the players in the event of injury. Fortunately, since the mid-90s, with the rise of the player associations, we've been able to negotiate good cover, which covers players for the event of career-ending injury, income protection in the event that they're unable to play, and TPD.
Okay.
But it does vary greatly from sport to sport, and it is all basically private protection under the terms of these collective bargaining agreements.
John, do you know that if you're playing for your local club, let's say, what's your local club? Football club?
Northcote.
Okay, Northcote. Do you know that chances are that if you sustain a serious injury that keeps you out of work, you will not be covered for your loss of income?
Well, if you don't have insurance, or if the club doesn't have insurance, no, you won't be covered.
Well, how are they supposed to check this?
At the same time, Tony, a player still has common law rights to sue the club or the ground facility in negligence.
That's if they can prove negligence. There's a lot of instances
in negligence.
And just curiously, John, you're part of a tennis association and you have to take out insurance every time you play.
Oh, yes. Any pennant player or competition tennis player has to take out private insurance.
And under the Victorian Workers' Compensation legislation, Accident Compensation Act, the only sports people covered by insurance are who? Worker.
Only jockeys, Tony.
Okay, jockeys. How come the association hasn't been able to get the coverage that jockeys have got transferred across to AFL footballers and soccer players and people like that?
Well, the main reason has been it's not been a huge priority until very recently because of the success of collective bargaining. Yep. But if it wasn't for collective bargaining, then I have no doubt that it would be a priority. And it is a priority for the player associations now because we are getting tired of this process that whenever we sit down to negotiate a new collective bargaining agreement, believe it or not, Tony, the employers are within their rights to be able to say, look, we won't insure the workers in the event of a workplace injury. We think that that shouldn't be the case. It should be a statutory protection absent a collective bargaining agreement. And it's interesting too what you're saying just about the local footy club and the local tennis club. You know, you remember that in sports for a long time, people thought, well, look, it's a voluntary assumption of risk.
Yep.
The chance of an injury is inevitable. And that is now being challenged in the context of professional team sports. I think that there's a change in culture, that people are no longer accepting that injury is inevitable, and that's why now there is so much legal scrutiny, for example, in the United States in relation to concussion.
Yep.
And we've also seen that with the AFL. The NRL now have concussion protocols. The A-League has a concussion protocol. And even the recent World Cup just showed how big an issue in football concussion is.
And Tony, especially also if the ground is not in an appropriate condition.
Oh, yeah. Look, most AFL grounds are in pretty good nick these days. There's been some issues with Etihad Stadium being too hard on the players and a lot of knee injuries occurring
And the
out there,
slipping nature of the surface.
Well, I mean, you talking about negligence before.
Exactly.
If the ground's too hard and it's conducive to getting knee injuries and things like that, your chance of proving negligence is so much higher.
Exactly.
Brendan, the other thing that's pretty big is this free trade issue. All of a sudden, everyone's up in arms, gone, Buddy Franklin left Hawthorn, although it was a blessing in disguise because they seem to have strengthened the club. It wasn't at the time. I was one of the first ones complaining that he'd gone. But, you know, they can go out there and negotiate. Boyd, he's just negotiated a $7 million 7-year deal. Is that good for the competition?
Well, let's take a step back and look at it in the context of sports. First, it's a restraint of trade issue.
Yes.
So, you know contract law, so any worker is entitled to pursue their trade free of any unreasonable restraint, and the onus is on the employers to be able to show that the restraint's reasonable. And it's only reasonable if it promotes legitimate objectives, competitive balance, economic viability.
Yep.
Now, the first big case was an English soccer player called George Eastham in 1963. He won a case against the transfer system. There's a legendary Australian rugby league player called Dennis Tuddy. He went all the way to the High Court as a labourer and won the case of Buckley and Tuddy. Silvio Fascini, of course, in 1983. Yes. We then had the NRL players, or the New South Wales rugby league players as they then were, in 91, challenged the draft. And so all of these cases have been won by the players, and there's been two key points to emerge from it. One is the rights of the players have been respected, but the free market has actually been better in driving these outcomes of competitive balance, economic viability. Yes. I don't think the AFL has a lot to concern about greater freedom of movement for the players.
And John, one of the players that Brendan didn't mention was Gary Buckenara, when he went to the Supreme Court. He stayed on the Hawks and won another 4 flags. So, I mean, you know, he had a successful career. And Brendan, I guess the issue here is that these footballers in particular, they've got a very limited lifespan. Is that correct?
Absolutely.
How long do you think the average footballer, how long does he play?
Well, look, it varies greatly from sport to sport, but if you're not established within the first 2 to 3 years, then it'd be very unlikely that your career will go for much longer. You know, in football, in soccer, we know that 75% of the players who are identified by their system as being good enough at the age of 18 are out of the game by the age of 21.
Just curiously, John, do you know that the Health Minister has said that private health insurers have warned that professional sports players should not be making claims for medical expenses for workplace injuries against the insurers and Medicare?
Under Medicare, yes,
Yeah.
exactly.
What do you think about that?
Well, look, they're working for an organisation. If the injury occurs whilst work is occurring, the employer is liable for that injury. So technically, the public shouldn't be liable, Tony, for those medical expenses. The employer should be liable.
But we said before that the Accident Compensation Act doesn't pick up anyone but jockeys.
Exactly.
Okay. Viewers, stay tuned. After the break, we're going to be dealing with some very interesting topics, including WADA and ASADA. Welcome back to the show. We're very fortunate to have Brendan Schwab, who's the General Secretary of Australian Athletes Alliance, a peak body for Australia's 9 major players' associations, which represents more than 3,000 athletes. Now, John, you're itching to get onto this topic. ASADA and the Essendon scandal.
Oh, look, Tony and Brendan, the Essendon Football Club, as we all know, has been in the news for the last couple of years. Now, my concern is the public is sick and tired of players that may have taken illegal substances and are getting away with it. Really, isn't that what we're talking about here?
Well, no, I think it's much more complex than that. I think that the public is actually tired that this process has taken so long, and there has to be serious questions about that. We're dealing with... I think the big lesson out of this is that the public is starting to understand that that the Essendon Football Club with its players is a workplace.
Oh,
and
yes.
that the players are entitled to the legal protection of a workplace. They're entitled to a safe workplace, and the club has a duty to provide that.
Exactly.
And here, not only do you have questions of the players taking substances that they don't know, and the AFL Players Association with medical experts will be monitoring this for a number of years, but we also have the players possibly having breached these rules of strict liability, these very draconian WADA rules, which can result in bans which would be career-ending for some of these
life
players.
Bans. But are they draconian?
There's absolutely no doubt.
Really? Because...
Well, the player's responsible, John. That's what he draconian.
Exactly.
Not the club, the
but
player
Tony,
is.
the public doesn't want drug cheats in sport.
But if you've got a doctor and you've got someone else with some sort of sports or some science degree saying, take this, it's not illegal, it's going to help you, it's going to give you endurance and this and that. I mean, surely you go to your doctor, you're relying on him to prescribe you, aren't you, John? It's
well,
that,
at the
isn't it?
same time,
Isn't it similar to
I
that,
think
Brendan?
players
Yes,
are pretty
no?
smart enough to know what they're taking.
I'm not sure if they're that smart. Oh, sorry, I don't mean to offend the sporting public, but I'm not sure if they're that switched on,
because
really.
in the end, we've had Ben Johnson over the years, Lance Armstrong, Asafa Powell, all these drug sheets. People are sick of it, Tony.
Yeah, Lance Armstrong is a pretty...
We don't want drug
This
cheats
isn't a case
in sport.
Of course, and nor do the players, and that's the key thing. If any stakeholder has an interest in a level playing field, it's the athlete. Because the athlete doesn't want to lose his or her career opportunity because he or she is competing with a drug cheat. So the athletes want a clean playing field. But all we ask for is one very simple thing. Let's decide every case on its merits.
Yes.
Lance Armstrong is not the Essendon Football Club.
Yep.
Lance Armstrong deserved a
That's
severe ban.
systematic.
But there's an inadvertent doper
systemic.
who's acted in accordance with the medical advice of his employer deserve a ban that's career-ending. It's absolutely ridiculous. It's time for the Australian sports to sit back, and I think this will happen post the AFL experience. The NRL, the Australian major sports have to sit back and say it's time for us to have a more effective anti-doping code. Because not only are these penalties draconian, when you actually look at the positive results, they're a fraction of a percentage. And the people that run WADA are saying that doping is in double digits, which I think is a ludicrous statement. There's no evidence for that statement.
They're spending
people
more
have
money.
to put WADA under the microscope.
They're spending more money on testing than people that they're discovering are breaching the code.
I think it's $500 million a year on testing.
But that's
so if
good,
you give me
isn't it? That's good for the
$500
game,
million,
isn't it?
no.
But Tony, that's good for the sport.
But the amount of people they're catching out is very few and far between, John. So in effect, the $500 million that Brendan's talking about could be put towards welfare of not only the major codes, but also the local competitions. You know, let's say someone gets injured playing for the local footy club and they've got no insurance. At least they could go towards...
I know, but we don't want drug cheats in sport, Tony.
No, who wants drug cheats anyway?
No one does.
Well, that's what's occurring. That's what's occurring. And we're seeing it every day.
John, I've been getting a lot of phone calls from Essendon players saying, assuming one day I develop cancer or some other problem due to the supplements that I've been given,
Exactly.
what are my rights? Well, I said, at this stage, this is what I've said, we don't know what's going to eventuate. So
But in the end,
advising?
but in the end, if an injury manifests out of those substances that they've been
They've
given
still
and
got a claim.
taken, they have a claim.
Yes. It's a little bit
Against the football club, the Essendon Football
It's a
Club.
little bit like asbestosis and mesothelioma.
Exactly.
You might be exposed to it today, but it doesn't manifest itself for another 30, 40 years.
Brendan, we've got an issue of the rights of the sports person and the rights of the game, and really the rights of the public also. It's a balancing act, isn't it?
Yes, it is. And then you have to ask yourself, should we depart from fundamental legal principles to have an effective regime against doping? And the fundamental legal principle that we would put forward is the right to a fair hearing,
yes,
and the avoidance of mandatory penalties, the right to make, for an independent tribunal or an independent arbitrator to impose a sanction based on the facts of a particular case. And in fact, the WADA Code is going worse. We were in the Senate committee the other day, and now, believe it or not, if a person takes a substance and everyone agrees, including the prosecutor, that that person was at no significant fault, that player still gets a 2-year ban. Why is that necessary?
That's outrageous.
But Brendan, isn't that the cost of being a sports star?
No, but
You've got responsibilities.
You're giving them too much credit, John. These guys are dependent and reliant
Tony,
on managers.
They're making millions and millions of dollars. They've got responsibilities.
Yeah, but they've got limited lifespan. Their career...
Yeah, and they're making millions of dollars in 2 years.
But how many footballers have finished playing... Let's say AFL. How many have finished playing the game and actually set themselves up for life?
I think
quite a few.
I think those comments that, you know, that I think the average wage these athletes in Australia, the figures you're quoting about, they may be true in the Premier League or in the NBA or in Major League Baseball, but in Australia, we are still have a situation where the minimum wage, for example, is $50,000, $60,000 a year.
Exactly.
The average wage is a couple of hundred. You're dealing with, and look, this is money. Which is well earned, and the players should be responsible with it. There's no question of that. But I think we have to be realistic that it's not the United States, and we still are developing a generation of players who, once they're finished playing, will certainly have to successfully transition into life after football.
And a lot of them
don't
have a good transition, do they?
Well, look, that's one area where the player associations are working more and more, and I think it's one of the biggest challenges that we all have.
And the Jockey Association recognised that. A lot of jockeys finished their careers. They didn't have enough money to survive. They become depressed and, you know, fell into alcohol and things like that. So they set up a scheme to cover that, to protect them.
Yeah.
A pension scheme. Was it pension or something along those lines?
Oh, yes.
Yeah, a pension scheme.
Yep.
Anyway, this episode's gone pretty quick. We'll have to get you back another time, Brendan, because... John, anything else you'd like to add?
Well, look, in the end, Tony, and we all know this, Brendan, anyone that's injured in the course of work or injured outside of work and suffers injury, well, they're entitled to compensation.
Brendan, I want to thank you for coming on board.
Pleasure.
I really appreciate your comments. John, as usual.
Thank you.
Viewers, thanks for watching. Go to our social media pages, Facebook, Twitter, and the like. Stay tuned for future episodes, and always remember to stay safe.